Judicial tyranny, specifically in our American court system, has usurped legislative jurisdiction. And I'm so bold as to add divine jurisdiction in our constitutional republic. We saw its egregious head again this past weekend after a Mississippi school district canceled Brandon High School's marching band playing of the Christian hymn, How Great Thou Art, during halftime at Friday night's football season opener. What was the reason? Well, it was decided that the singing of the hymn was too similar to a recent ban by United States District Judge Carlton Reeves that was given to the Rankin County School District on July 10th, saying it promoted Christianity during school hours after it had agreed to stop. So Reeves fined the district $7,500 and again ordered it to stop sponsoring prayers at graduations, assemblies, athletic competitions, and other school events. That means, and I quote, administrators, teachers, and staff of the Rankin County School District may not participate in any religious activity or solicit or encourage religious activities at school or while performing duties as an RCSD employee. However, this did not stop dozens of parents and students and fans from performing How Great Thou Art on their own. Parent Kimberly Moore expressed, "It bothers me because you look at the schools and of all the school shootings and all the bad things that are happening and wonder why. Well, it's because we're allowing evil to step in," she concluded. Lamentably, America has encouraged this evil for decades. Examples like Ingle versus Vitale in 1962 and Abington School District versus Schempf in 1963, the United States Supreme Court established what is now the current prohibition on state-sponsored prayer in schools. Evil is succinctly summed up by what the Ten Commandments prohibit, and to display this warning sign to potential violators in public was never questioned until the Supreme Court ruling in 1980 of Stone versus Graham that students could not even be permitted, voluntarily or otherwise, to see a display of the Ten Commandments. The majority view stated, quote, "If the posted copies of the Ten Commandments are to have any effect at all, it will be to induce the school children to read, meditate upon, perhaps to venerate and obey the commandments. However desirable this might be as a matter of private devotion, it is not a permissible state objective under the Establishment Clause," unquote. So the legal question I present to you is whether this clause has been violated. In other words, does singing a hymn equate to Congress making a law, the effect of which is to establish an official United States religion? Well, the answer seems to be clearly no, for at least two very simple reasons. Number one, Brandon High School is not the Congress. And number two, a hymn being sung is not a law, it is simply a song. In order to find that a hymn sung in Mississippi, or anywhere else, is a violation of the Establishment Clause, the first thing you have to conclude is that the Brandon High School is in legal contemplation the Congress of the United States. Crazy, you say. Well, I agree. But this is exactly the conclusion the judge maintains through a legal fiction the courts call the incorporation doctrine. This unconstitutional usurpation of federal authority over America's schools is the source of our issue and something I will expand on more in weeks to come. You will find out that this overt attack on our students' faith is part of a bigger plan. I leave you with the words of Founding Father Fisher Ames, who provided the wording for the First Amendment that every judge I've referenced used as a legal basis to eliminate biblical references. "The Bible," said Ames, "is the source of sound morality and behavior in America, and that we must never let it be separated from the classroom." This is Jake MacAulay with the Institute on the Constitution, bringing you the American View.